Hello, everybody. My name is Heather Brell, and I am the event coordinator for the Advocacy and Outreach Committee within the Junior League of Long Beach. I will be your moderator for this session on the role of the Superior Court, which is appearing on your screen now. Shared with you today are the prompting questions that each candidate may choose to address during their remarks. Each candidate will have 4.5 minutes to speak, and the order of each speaker has been randomly assigned. If anyone watching has any questions they would like to ask, time permitting, please submit them to me in the chat box. This breakout session will be 30 minutes long, is being recorded, and will be posted on the League of Women Voters website for public viewing. At the end of the 30 minutes, all participants will be brought back to the primary room where we will hear some closing remarks. The prompting questions addressed in this session are on the role of the Superior Court. What are your specific connections or experiences with the Superior Court and how it operates? What strategies do you use to maintain objectivity? What would you do if the law required you to make a decision that was against your opinion or personal beliefs? And what would you explain to younger voters about why they should be specifically interested in who sits on the Superior Court? I believe first up was Fernando Barreto, so you may begin.
Thank you. Again, my name is Fernando Maria Barreto, and I have been a deputy district attorney for the past 16 years. So I always tell people that the courtroom is my office. I'm there almost every day, and I have become very intimately aware of how the courtroom works, how the attorneys function in the courtroom, and how everything works together. Sorry, the screen disappeared, so now I can't see. I'm working off of my phone, so I apologize. I'm sure there's nothing you can do about that, Heather. Oh, thank you. So how the court operates, I am extremely familiar with how it operates and how trials work, how the day-to-day function works, how what we call a calendar works, how we call how we call each case. And the strategies I use to maintain objectivity is when I'm reading a case to consider it to be whether or not charges should be filed, because that's one of the things I do. I try not to read the name of the person who is being accused of a crime, because sometimes that will give away gender, race. So I try to not look at that first. I also will step back and ask myself, if this were a different, once I do know, if this were a different gender or a different race, would I treat this person the same way? I do that when filing charges, when thinking about dispositions on cases. I always try to look at it from different sides. I also do that when I'm trying a case, try to look at it from all sides to make sure that I understand the case from every facet or every viewpoint. What would I do if the law required me to make a decision that was against my personal beliefs or my opinion? I would have to make that decision, because we as judges are not there to impose our personal beliefs or impose our personal opinions. We are there to apply the law. We are there to apply the law equally in all cases. We can interpret the law, but we're not there to make law or change law. And so even if I may not like the decision I have to make, that's part and parcel of the job. And what would I explain to young voters about why they should be interested about who sits on the Superior Court? Well, who sits as judges is very important, as we've seen in current events. But on the Superior Court, the person who's interpreting a individual's case will decide what kind of, on a lesser case, on a case that, let's say, is not a life case, can decide whether or not this person deserves probation, whether or not this person should go into programs, what kind of rehabilitation this person should have. And it's that ideology or that thought process that can make a difference in a person's life. If a judge only believes in punishment, then they're not going to have the same impact on the community as a judge who believes and wants to focus on rehabilitation. So that is why everyone, not just young voters, but everyone should care about who sits on the Superior Court. And it's not just criminal cases, but also civil cases, family law cases. These are all Superior Court cases, and it's all the judicial candidates. We don't get to pick where we end up on our assignment. So we can end up in any of these courts. So these thought processes can go into any of them. So that's why it's important that we understand who will be filling these vacancies. I'm not sure how much time I have left, if any.
You have 9 seconds left. So,
so thank you very much.
Thank you very much, Fernanda. Next up is Melissa Hammond. And Melissa, would you like?
Can I say one more thing?
Yeah.
I'm sorry. My phone is about to run out of battery, so I do have to go, and I apologize that I won't be here for questions.
Thank you. Melissa, would you like me to have the slide remain up, or do you want me to stop the screen share?
Yeah, I don't need it up. I'm familiar with what it's asking.
Thank you. You may proceed.
Okay. So hello again. Again, my name is Melissa Hammond. I'm running for Office 118. I was basically born into the Superior Court. I've been going to court with my dad, a criminal defense attorney, since I was about 5, 6 years old. Other kids went to playgrounds, and I went to the courts and jails in Los Angeles to talk to my dad's clients. I've been working in the Los Angeles Superior Court myself for almost 20 years now. My experience has been in civil litigation, as well as criminal prosecution and criminal defense as a public defender. I've been in public service for over 17 years. I practiced in almost every Superior Court in Los Angeles at one point in time, and I'm endorsed by over 60 Superior Court judges and bench officers. I tell you this because I really want all of you to feel comfortable to know that I am very experienced in the Superior Court, and I'm excited to take this next step to become a judge. I know it can be fair since I've done hearings and trials on both sides of the courtroom. I understand the perspectives of the accused, of their families, the victims and their families, and the witnesses in a case. I also understand the perspective of plaintiffs and defendants in civil litigation. This perspective helps me maintain objectivity in the court. When a defendant is brought out in court before me now as a DA, I know what has gone on in lockup just before that, what the general discussions with the attorneys might have been, having talked to hundreds, if not thousands, of people accused of crimes in lockup myself. Until you have done both sides in criminal and civil, you really have no way of truly understanding that perspective. I'm going to tell you quite honestly that I'm very well balanced. I do not have strong personal beliefs or political views, which is why I know that I can be very fair to all sides. I believe that all people accused of crime should be treated fairly, that victims should be heard, and that their families should be well informed about the case. I always try to explain things in a simple manner to victims and their families so that everyone can understand what's going on. I also explained issues in simple manners to my clients when I was a public defender and their families. Now is a very interesting and significant time in the courts, as I'm sure you're all aware. As I stated earlier, I am one of the only people in my particular seat in 118 who actually practices in the LA Superior Court. I am the only woman in seat 118 who currently practices in the Los Angeles Superior Court. And I'm the only woman in seat 118 who currently serves the public. This is important, especially given what's going on right now with women. We need more women judges. Only a third of judges are women, which is not in line with the proper ratio of women to men. As you know, we also need people who are currently familiar with the Superior Court, not people who worked there once upon a time. In the past year, there has been so much change in the court, with new legislation from the governor regarding enhancements, aggravating factors in sentencing, resentencing, and more. There are also new directives in the last year issued by the district attorney. Almost every day, I am reading a new law or new directive that has come down in my email and trying to understand it. Someone who has not practiced in the Los Angeles Superior Court for years, or even in the last year, would have no knowledge of the overwhelming amount of new legislation that has been passed. So as to younger voters, they really need to know that more women and people who are familiar with the current state of the Superior Court and what's going on in the Superior Court every day should be the ones sitting as judges. It is extremely, extremely important to make sure the Superior Court is composed of experienced, intelligent, and strong women like myself. I am also ready to take on this role in the prime of my career, having lots of energy and enthusiasm to learn new areas of law. I also really want to work with children. I would love to work in juvenile, which is where I've worked in juvenile before, or dependency court, which I've worked in a little bit. And I believe that you can really make such an impact on youth. And having 3 children of my own, I understand children very well. My kids are fairly young, and I really feel like I can make an impact on those kids and try to stop the cycle of kids repeating the same mistakes as their parents and not having proper role models. I really feel that I can make an impact in the juvenile justice system. So based on all of that, I know that I have some time left, so I would love to answer any questions that you may have about anything I've said. And I'm really thrilled to be here with all of you. Thank you.
Thank you, Melissa. Next up is Albert Robles.
Thank you. Martin Luther King had a quote that said, a threat to, or injustice anywhere is a threat to justice everywhere. And I believe that. As we say, younger voter, I'm assuming 18, 19, you don't think about that too much. But the fact of the matter is, young people have an incredible equalizer when it comes to elections. Young people generally don't have a great wealth of experience, don't have many resources, maybe aren't, without due respect, aren't as smart as they will be and will become. But the one thing that they have that is equal to everybody, regardless of their socioeconomic status, regardless of their age, regardless of where they live, regardless of their background, their ethnicity, is the right to vote. And that right to vote is equal to everyone. So if you're 18, you need to vote. You need to tell all your friends to vote. And who you vote for judge matters. Absolutely matters. May not matter for you. I hope that young people never have to go before the court, other than an attorney, of course, or jury duty, but not as a party. But a friend of yours or a family member may have to go before a judge. And it's imperative that when that person goes before the judge, that they are treated fairly, without bias, with due respect to all their fundamental rights. And there is situations, as was said by another candidate, where there are good judges and bad judges. And the bad judges need to be replaced. And your participation in our judicial process and in your opportunity to vote in this upcoming election is absolutely critical. I've been an attorney for 20 years, and I've been in courtrooms throughout the state, throughout LA County, both federal and Superior Court, the Court of Appeals, and I've seen it. There are good judges and there are not so good judges. And sometimes you wish you didn't have the judge that's before you, but sometimes we just have to deal with it. And you, as young people, have an incredible opportunity to make your voices loud and clear. 1, by voting, but 2, by voting for your preferred judicial candidate, a person that's going to respect your fundamental rights as an individual, one that's not going to be biased, not only against you, but against anybody, and that's going to abide by the rules of judicial conduct and not be questioned as to whether or not they're abusing their authority. It's imperative for the integrity of our judicial system that judges act accordingly and judge fairly and objectively. And it's difficult when we see that not happening, and for us to continue to believe in the system. I understand that. I believe in our judicial system. I think it is the best in the world, but it's not perfect. It needs improvement. And that improvement only comes from the participation of younger individuals to make their voices heard. And the best opportunity you have to make a loud statement is during the election process and voting for the judge who is best educated, best experienced, and best committed, as proven by 30-year record of public service, to be objective, to listen to both sides of a situation before making a ruling or arriving at a decision. That's absolutely critical. And I think that there is incredible opportunity for young people to get involved. One of the things that I hope to do if elected as a judge is to take just that opportunity and make myself available to younger people. As a professor at Rio Hondo Community College teaching business law,
Albert, your time is
I
up, so if you
mentor
can wrap it up,
individuals.
that would be great.
Thank you.
Oh, okay, thanks. Thank you. Next up will be Kevin Mcgurk.
Hello, can you hear me all right?
Yes, we
Hi.
can.
Okay, can you see me okay? I've moved from the prop area to the car. Let me start by saying, in terms of familiarity with the courtroom, the first question, obviously, as I stated earlier, I've spent a lot of time there. And I think it's important, uniquely important, to have been practicing in a courtroom now or in the last 2 to 3 years or so, due to the rapid changes we've had in criminal law. It was mentioned earlier, I just got in the car, and I believe Ms. Hammond had mentioned it. It is true that there's been so much sea change, and when you're a defense lawyer and you have a client in court, you need to stay up to speed. We have an implementation problem in our courts right now, where the law in many courts is being applied as it was 3 years ago as opposed to today. So it really is almost experience plus to be in court in the last few years. In terms of maintaining objectivity, I would say, first of all, if you're running for the public's permission to be a Superior Court judge, objectivity should be one of the first things on your mind. It's sort of like knowing how to swim to apply to be a lifeguard. It's a prerequisite. But at the same time, we all have implicit bias and we all have our own unconscious bias. So how I look at it is, I'm always asked, or a lot of times I've been asked, what's your judicial philosophy? And I always say, my philosophy is treat the courtroom like it belongs to someone else, that it's not your living room. Too many judges think it's a fiefdom, and it's not. And if you treat the courtroom like it belongs to the public, that they're allowing you to sit there, that it's a lease without an option to buy, that will inform every decision you make. And that will keep objectivity at the forefront of your mind, because you can be as biased as you want in your living room, but when you're in a cathedral that belongs to the public, the entire public, you aren't allowed to be objective, right? And it's self-evident, of course. So if you think of it that way, it will really allow you to put those implicit biases aside. The second question, I believe, was if there were a law that required me to make a decision that was against my opinion or personal beliefs. Well, the word required says it all. If the law is so explicit that it requires a decision, that's the end of the analysis. I've seen too many judges, if you've been a lawyer for a while, you see the word shall and may a lot in the penal code. And I've seen too many judges try to turn them into synonyms, and they're not synonyms. Shall and may do not mean the same thing. If it's required, if it's so explicit that a decision is required, irrespective of my personal beliefs, it has to be followed. However, in most instances, there is some level of judicial discretion that's available. And of course, I would use that thoughtfully and pragmatically to the best of my ability. But the word required in the question, I think, is self-evident. So if a decision is necessary under the law, I would make it. Right now, as I've stated a couple of times now, we're changing into a certain direction where we have a more balanced judicial system in terms of sentencing. If the public decided to change gears and go the other way, I may not like it personally, but I would have to enforce that law. In terms of explaining things to younger voters, I would say two things. I'd say, one, other than wanting to work in a courtroom, no one expects to be in a courtroom, and yet we're very busy. You may find yourself there and you don't expect to be. So you certainly would want fair, competent unbiased individuals working on your behalf. So I would try to explain that to them. And second of all, I know the narrative is that young people are untethered from our civic institutions. I don't know if I buy that narrative completely, but I understand why they may be, because the results and frankly the perception aren't where they need to be. We need to do a better job of showing competence and fairness and understanding to people outside of our little personal orbits. So I would explain to them that they're going to own these civic institutions as they go forward, and decisions in courtrooms, whether it's criminal, whether it's unlawful detainer, whether it's family court. Our society is intersectional. These have huge repercussions to families, to businesses. It affects them whether they're in court or not. And the resources we use in the criminal justice system, or the justice system generally, obviously has a huge impact on funds or resources they may want to apply to other things. So this is something that they need to be engaged in, involved in, and frankly, we need their input to succeed, because we can do better. And maybe one of the reasons we're not doing as well as we could is because we don't have as much input from young people. So I would really encourage them to engage and to frankly help us out, because if you ignore the youth, you do so at your peril. I'll leave it at that.
Thank you, Kevin. That does conclude your time. We are a little, Mr. I think it was Naz Curry didn't show up tonight, so there's only 4 panelists in this room, so we are going to have a little bit extra time. I do have a question for the panelists, and that is, whoever wants to take this, raise your hand or just unmute yourself, and we can go by that. We have approximately 6 to 7 minutes left. And that is, if you were a judge and you became aware that there was some implied bias being exhibited, I don't know why this share screen keeps going to other screens, but kind of along the lines of remaining objectivity in the courtroom, if you became aware that your courtroom staff was exhibiting some implied bias, what would you do within your courtroom in order to identify that and eliminate that within the courtroom in order for you to remain objective and for your court staff to remain objective in the way they treat parties within your courtroom?
Well, if I may.
Yes, was that Kevin?
Well, Albert.
Or no, Albert, sorry.
Yeah. It depends on when you say become aware. If as a presiding officer, I see it personally and therefore, it's more like it actually happened as opposed to someone telling me. It needs to be dealt with immediately. If I've seen it directly, I would immediately deal with it. If preferably not in front of everybody, but I'm imagining in your scenario that there's a proceeding ongoing, and if it happens while the proceeding is ongoing, I think it needs to be dealt with immediately. If it comes to my attention after the conclusion of the proceeding, again, it needs to be dealt with immediately in either case, because the staff needs to know, the employees in that courtroom need to know that everyone needs to be shown due respect. And unless it's dealt with immediately, I think it's going to linger and give the perception that it's somehow acceptable or could be tolerated.
Thank you very much for your response. Let's give Mr. Mcgurk, did you have a response? I see your hand up.
Yeah, sure. Well, it'll be dealt with immediately either way. There's 2 ways to look at it. If there are attorneys in front of you acting in that way, the canon of judicial ethics makes it clear that not only is a judge not permitted to act in any way that would show bias to another party for a variety of areas, but it gives the judge an affirmative duty to make sure that the attorneys before him or her also don't act in such a way. And if they are, the judge has an affirmative duty under the judicial canon of ethics to act. And that can be anywhere from sanction to contempt proceedings. Obviously, it depends on the nature and how many times it occurs. If it's judicial staff, like the judicial assistant or the deputy, that's probably in a different area than the canon of judicial ethics. And it will be dealt with more in it will obviously be dealt with immediately, and it'll be dealt with swiftly. It just can't be tolerated. And the court perception is just as important as reality. That's the public's courtroom. Everyone needs to feel that they're getting a fair shot. that whatever ruling they're getting is due to a fair and thoughtful application of the law and not some implicit or explicit bias, and it just simply wouldn't be tolerated by anyone in the court.
Thank you, Kevin. Melissa?
Yeah, I mean, I don't want to be repetitive, but just to kind of reiterate some points, I wouldn't tolerate any kind of bias in my courtroom. I would definitely, depending on the situation, talk to the person involved, not in the presence of other people, if I could, because I really think it's very important to treat all courtroom staff with respect. And I see that in my current practice as a DA, as well as when I was a public defender. I really just am very respectful of everybody in the courtroom, the judicial assistant, the bailiff, anybody that's there. So I would definitely try to do it not in front of everybody, but I would just make it very clear that such biases would not be tolerated in front of me. And I also think that I would try not to be biased to the extent possible with the cases that I decide. And that's what I currently do as well as a DA. I try to get rid of all my biases when I decide cases. And I know that everybody has some biases inside of them. It's impossible not to have some. And we have to just be aware of them and just try to confront them and just be as unbiased as we possibly can when we're deciding cases.
And on that note, Melissa, that's actually kind of more what I had in mind when I asked the question. So let me direct it more towards that. I think we all do have implied bias, and I don't necessarily think it's always people are cognizant of it. So what would you do in your courtroom to fix it? Like, would you offer training? Would you yourself go to training? Would you ask that, your court staff go to training? Or, are there any methods that any of you would employ in order to help yourselves and the staff identify any implied biases that you may have? Because I think we all do. And to kind of bring a sense of objectivity back to the courtroom through that measure. Melissa, you raised your hand.
Yeah, I just wanted to continue that. So I do go to trainings myself on implied bias. We have some at the DA's office, and there's actually one coming up on Saturday that I plan to attend. But I think it's really important to be cognizant of your own biases, because thinking that we don't have them is crazy. We all have them, we're born with them, and just taking a step back, it's like anything else. You take a step back and you think about the thought process in your head, and you say, okay, I have this implied bias. What do I do about it? So I think that the trainings are extremely important in figuring that out for us. And also I would try to get my court staff, if that was possible, to go to trainings as well. I would have to see what kind of trainings were offered for the support staff, but I'm sure there are some. And I think that it would be extremely important for everybody to understand this issue so that they could rectify it within themselves and just help the court system in general.
Thank you, Melissa. We have just a couple more minutes. Does either Albert or Kevin want to comment on that last part?
Sure.
Go ahead. Go ahead, sir. I'm sorry.
I would just add, I would echo that, but I would also state that I think there should be opportunity for everyone in the courtroom, the staff, the bailiff, to also feel comfortable enough to bring it up to the judge to say, Your Honor, you said something that could have been interpreted this way. Your Honor, you did this. And I think there needs to be that comfort level. And unfortunately, that doesn't always happen. And I think that does come from mandating that both the judge and everyone working in the courtroom participate in these seminars and these training sessions. They should be mandated. I actually thought they already were. And to the extent that they're not, then they need to be.
Thank you, Albert. I just want to give Kevin a quick chance to respond as well.
Thank you. I don't want to belabor the points from the last two speakers. I agree with both counts. We also have training with the PD's office. And I do think that, in a courtroom, anyone that practices court realizes that the judge, the judicial assistant, the bailiff, the court reporter, all court staff, everyone has a role to play in the court to make it go. And so you're in many ways a unit, and that's a conversation that needs to be had before a court day. But look, we understand we all have to acknowledge we all have implicit bias. And if you see something, let us know, talk about it. And that's me, the judge, if I'm elected or whatever the case may be, but acknowledging it's the first step. And you need to have those conversations as a collective. So we're all on guard. We all understand that we're having people from all walks of life come in a variety of issues. And if there's ever going to be a problem with, unconscious bias, this is the forum where it's going to rear its head. And it's the last forum that it can. So you really need to have those conversations, more than sporadically, to make sure everyone's on their toes, and to have that culture that people can, freely say, look, you don't realize you did something. And actually, I'm more aware of it than you, and you need to change your behavior. That's something that needs to happen in the courtroom.
Great. Thank you so much for all of your comments. And thank you so much for all of the attendees. I'm going to invite everyone to go back to the main room for some closing comments at this point. Thank you so much.
Thank you.
Thank you.
Welcome back, everyone. I hope everyone was able to get a lot out of tonight's program. And on behalf of the Junior League of Long Beach and the League of Women Voters, we'd like to thank you for attending tonight's forum and learning more about the judicial candidates. We will follow up with all of the attendees via email with the linked videos of tonight's forum when they are posted and made available to the public. Please feel free to share with your friends, family, and professional networks. I'd also like to give a special thanks to all of our judicial candidates tonight for joining, and I hope you found this to be fruitful. I know there's not a lot of these types of forums for judicial candidates, and so we're very excited that you were all able to join us. Please follow us on social media. You can visit jllb.org to learn more about the Junior League of Long Beach, and lwv.org to learn more about the League of Women Voters. And again, thank you all so much for attending. We hope you have a wonderful evening.